Hello, welcome to another course on intellectual property. I'm Eric Hanscom. I'm the managing attorney here at Intercontinental IP. We're a Carlsbad-based intellectual property law firm. We do patents, trademarks, and copyrights, and we hope that you enjoy the course. To follow along with this video presentation, please download the PowerPoint presentation from our website. The link will appear on your screen right now. It's www.iciplaw.com. The next slide is dealing with patent attorneys and patent agents. And a lot of people ask, well, what's the difference between a patent attorney and a patent agent? Well, a patent attorney is somebody who graduated with a degree in the sciences as an undergrad, went to law school, passed the state bar, and passed the patent bar. Here in California, we're famous for having a really rough state bar. Well, the patent bar has a lower pass rate than the state bar does. So it's not exactly a piece of cake. A patent agent, on the other hand, is somebody who has the undergraduate degree in the sciences and took the patent bar but never went to law school. So a lot of people ask, when do I go to a patent attorney? When do I go to a patent agent? Well, one of the advantages of going to a patent attorney is because they're an attorney, they can offer legal advice and they can represent you as an attorney. One of the advantages of going to a patent agent is that patent agents, first of all, they're usually cheaper than patent attorneys in terms of their prices. The other advantage of going with a patent agent is that with patent attorneys, most of them are people who did 4 or 5 years in undergraduate studies in the sciences, knew they were going off to law school, so they went off to law school, and they basically became lawyers after that. Your average patent agent, on the other hand, is somebody who has at least an undergraduate degree in the sciences and may have worked in the field for a number of years. So if you have a highly technologically advanced invention, perhaps in a very narrow specific field, you may be better off going with a patent agent who may have a lot of training in that specific field. So again, patent attorneys and patent agents, they both have the undergraduate degrees in science. They both passed the patent bar, but the patent attorney went to law school and passed the state bar as well. Let's move on to the next slide. This basically lays out the 4 types of intellectual property protection that are most common for first-time inventors to be thinking about. And this would include a patent, a trademark, a copyright, and a trade secret. So what's a patent? Well, a patent is one of the last legally recognized monopolies. It's a monopoly, a temporary monopoly, over an idea. And basically, to quote the law, a patent gives you the right to exclude others from making, using, or selling the invention in the country in which the patent is granted during the lifetime of the patent. Trademarks, on the other hand, are designed to protect business identities. We have patent law because if there wasn't a way you could protect your ideas, there'd really be not much of an incentive to be an inventor, to be a scientist, to do R&D, because all the time that you put into developing your invention could easily be copied by somebody else who didn't have to pay all the expenses involved with developing an idea and instead could just rip you off, basically. The goal behind trademark law is a little bit different, and that is to prevent consumer confusion so that when somebody is buying a product off the shelves, they know who made it. And just go to a country that doesn't honor trademark law, and you'll find, for example, Rolex watches that are made by Rolex and made by probably 2,000 or 3,000 other companies, and that's why you find the Rolex watch for sale for anywhere from $20 to $20,000. Sometimes it's kind of hard to figure out whether you're getting the real thing or a fake. So that's the goal of trademark law, again, is to allow the consumer to pick the good or service that he or she is interested in. And so trademark law allows you to protect anything that's associated with your business identity, which for most inventors and most small businesses is the name of the product or the name of your company. Trademarks can also protect logos, slogans, any kind of mascot, and in some kind of unusual cases, trademarks can either protect things like scents and colors. Now, this isn't the norm. For most inventors, you're looking at the name of your product or the name of your business. But again, trademark law can be used to even protect the shape of something. For example, the shape of the Coca-Cola bottle is trademarked because Coca-Cola was able to convince the U.S. Patent and Trademark Office that the shape of the bottle is a distinctive feature and that consumers recognize the hourglass shape as being a Coca-Cola product. The last type of intellectual property that we're really going to go into some depth on in this course are copyrights. Now, copyrights protect a form of art, artistic expression, and they give the author or the owner of the copyright, which are not necessarily the same person, they give that person or company certain rights that are very important in terms of making money off the creative work. And these would include the right of reproduction, among others. So basically, when you hear about all those little 13-year-old kids getting sued by the big music houses, they're getting sued for copyright infringement. Big music houses saying, hey, little kid, you downloaded my song for free, you distributed it to your friends, so basically you infringed my copyright. Now, when they hear the word copyright, a lot of inventors immediately shut their minds off and shut their ears off because they think copyright just applies to artists. And yes, in a traditional sense, copyright can be used to protect movies, songs, photographs, sculptures, books, things like that you would traditionally associate with copyright. But what you should realize too, especially if you're an inventor, is that copyright can be used to protect many aspects of your invention, which could include things like your website, your owner's manual, any packaging, any promotional materials you produce, anything you do for a trade show. These can all be protected by copyright. So inventors, don't close your ears when you hear the word copyright because it may apply to you. The last type of intellectual property that I'm going to go over, and we're going to go over this in a very short depth because it really doesn't apply to most of the first-time inventors and small businesses out there, are trade secrets. And a trade secret is something that you don't file for protection on. You can't send an application to the government with a check along saying, I want to get a trade secret on that. Instead, a trade secret is something that you claim. And if you have an invention that probably isn't patentable, but would be very difficult to reverse engineer, a trade secret may be the best protection that you can possibly hope for. Because one of the problems with a patent application is that you have to specify in the patent application exactly how you make your product or exactly how you use your product, to the point where when your patent expires, anybody out there can take your expired patent and use it basically as a blueprint to copy your invention or copy the way that you're using the invention. And so a trade secret, on the other hand, it doesn't have a natural expiration date like a patent does. And so, for example, the formula for Coca-Cola and the method by which it's made, that's a trade secret of the Coca-Cola Corporation. They were smart enough way back in the 1860s to figure out that Coca-Cola may be a viable product 20 years from now. And so rather than filing for a patent on it, which would have given them roughly 2 decades of protection, instead they just called it a trade secret, didn't let the secret out of the bag, and it's been a viable product for over 150 years now.